Welcome to the 14th Annual Creighton School of Law and Omaha Bar Association Seminar on Ethics and Professionalism. I'm Dave Sommers, Executive Director of the Omaha Bar Association, and I am here to do the welcoming remarks for the Omaha Bar Association. As you know, this event was scheduled to take place in March of 2020 at Creighton in the Hickson Lead Auditorium in the Harper Center. But due to COVID, we had to postpone that event, and it was hoped that we would be able to do this in fall in person, but that doesn't look to be the case. So we are doing this online, and the good news is that you can get all of your Nebraska and Iowa CLE credit online this year, and so this has been approved for 2 hours of ethics, professionalism CLE in Nebraska and Iowa. And to get your credit, please email me at dave@omahabarassociation.com. If you're looking for any of the materials from the speakers, that will be included on the Omaha Bar Association website, which is omahaparassociation.com. And we'll have links to connect with the speakers if you'd like to ask them any questions on their speeches, their presentations for today. And while we love to see you in person right now, we are doing this remotely, and we will be back in person as soon as possible. We miss you. We miss connecting our attorneys with one another and with the bench, and we will continue to do online programming as we need to until we can meet again in person. I need to really shine some light on the founding presenters of this event who have kept this event alive and well and growing over the last 14 years. J. Scott Paul of McGrath North, during his presidency, came up with the idea along with Professor Steve Sieberson at Creighton Law School to put on a CLE for ethics credit, which was newly required at the time. And here we are 14 years later, continuing that tradition, and Scott and Steve are both presenters still to this day. So thank you so much, Scott and Steve, for your hard work on this. And also, Mark Weber, we're very happy and excited to have you presenting this year, albeit not in person, but thank you so much for lending your voice to this presentation as well. We like to hang our hat that this is a huge member value. If you're a member of the Omaha Bar Association, this CLE is free. If you are not a member, it is $75. But if you're watching this as not as a member and you want to join, we'll comp that $75. We'll reduce your membership fee $75. So please take advantage of that. We have plenty of CLE that we offer for free or for reduced amounts. And we would love to have every single one of the people watching this as Omaha Bar Association members. We have an on-demand page for those who are looking for their CLE for the rest of the year. You can find it on the Omaha Bar Association website. It's very prominent at the top of the page and in the banner ads. So if you're looking for on-demand CLE to get you to your 10 for the year here in Nebraska, go to the Omaha Bar Association page. If you're a member, you get a lot of those hours included in your membership fee, or at $10 an hour. We'd like to thank our 2020 Platinum level sponsors of this event and every event that we do, Lampton, Dugan, and Murray, and the U.S. Marine Corps, also a Platinum sponsor this year. Thank you so much. And thank you finally to Creighton Law School for being a partner of it, with the Omaha Bar Association for so long. We call it our home, our office, which we're not at right now, but our office is located in Creighton Law School and has been since that building opened in the 70s. And we really do enjoy this close relationship that we have with Creighton Law School, that we put on this event jointly and together. And we look forward to continuing that relationship for many, many decades to come. At this time, I'm going to turn over to the Dean of Creighton Law School, Dean Josh Fershee. Dean Fershee.
Hi, I'm Josh Fershee, and I'm the Dean of Creighton University School of Law. And I'm thrilled to welcome you to the 14th Annual Creighton School of Law Omaha Bar Association Seminar on Ethics and Professionalism. I know it'll be a great program, but I'm sorry we won't be able to gather together as a community. That has been the story for far too much of 2020. Our law graduates and those from the University of Nebraska have faced a challenging time, and their path to bar licensure has been varied and stressful. Nebraska and Iowa were able to hold their bar exams, while other states delayed their exams, and some will try to move to an online exam. Still others have canceled their fall exams, and some have adopted or are still considering diploma privilege for 2020 applicants. During these times, our faculty and staff have been remarkable in showing support, and the legal community has worked to help law graduates financially and otherwise in ways that make me proud of our profession. And our students have been resilient and focused through some incredible hardships. Watching them navigate these uncharted waters gives me great hope for the future of our profession too. As lawyers and educators, the past several months have showed us that we can do things that we did not think were possible. We moved online to teach classes at the end of last semester, and all our summer online courses were online. And we did it quite well, and that is what I'm really proud of. It's not what we would choose to do in most circumstances, but we've made it work, and practicing lawyers and judges have had to do the same. We're evolving and improving because we must. There will be a time, and I hope soon, that we can return to our more traditional modes of interaction and education. But I'm also convinced that when we do, we'll all have developed skills and perhaps some compassion that will make us even better at what we do. We will continue to face a number of challenges in the coming weeks and months, and I'm confident that we are up to the task. Let's keep at it, take care of ourselves and each other, and look for ways to make our society more fair, more just, and more equitable. Good wishes to each of you, and take care. I hope to see you again soon.
Good afternoon, good morning, or good evening. I'm Steve Sieberson. I teach ethics at Creighton Law School, and I have been for the last 14 or 15 years a co-chair of this ethics seminar with Scott Paul. We've been working closely with Dave Sommers of the OBA, as we did with some of his predecessors at the OBA. So I'm going to be giving kind of a black letter law presentation today. And my topic, as you can see, is called Legal Ethics as Three-Dimensional Chess. Now, three-dimensional chess is kind of a popular buzzword these days. As I see it, it's a let's just say simile for being able to walk and chew gum at the same time, or keeping a number of balls in the air, juggling, multitasking, you name it. But the thesis that we have here is that legal ethics is not just a two-dimensional matter of your responsibilities to your client. That's what we think of primarily. And if we look at the rules of professional conduct, they mostly focus on the relationship between you, the attorney, and your client. And so the thesis of this presentation is that under the RPCs, you do have those duties to your client, but, and this is the three-dimensional aspect of it, you also have duties to opposing parties and counsel, you have duties to third parties and the public, and you have duties to the system of justice, the legal system, if you will. And I was thinking about this when I was teaching ethics recently. I was thinking about the fact that, oh, that's interesting. There's something there in the rules that tells me that I need to look beyond my client. Now, we all know that. We know we have broad responsibilities as lawyers, but I was kind of surprised as I started perusing the rules and the official comments. I was kind of surprised to find out that quite often your other responsibilities are mentioned. And so that's what we're going to be talking about today. So the rules of professional conduct are broken down into 7 or 8 parts. It's the first 4 parts that we're going to talk about. Now, the most extensive part of the rules is part 1, and that is the client-lawyer relationship. That's where so many of the rules are. Part 2 is just a small section entitled Counselor, but really what it refers to is some special roles that the lawyer has. We'll see that. Part 3, Lawyer as Advocate, that has to do with how you conduct yourself in court proceedings. Part 4 is a fairly short section having to do with persons other than your client. So we're going to go through these one at a time, and I'm sorry, the mouse just jumped on me. Here we go. Let's start with Rule 1.2. So we're going to go through the rules one by one, and they're not all covered here in this presentation, but let's talk about what they give us. And by the way, I'm going to back up for 1 second and mention that in the preamble to the rules, preamble paragraph 5, it does talk about the fact that a lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate. It also says that you should demonstrate respect for the legal system and for those who serve in it, like judges. And some of these are the same words that we will find in the actual rules. It says in Preamble 9, the principles underlying the rules include your obligation to zealously represent your client, but within the bounds of the law and remaining a professional, maintaining a professional, courteous, and civil attitude toward others. So then, here we are, Rule 1.2. We know this rule as the allocation of authority, and if you've studied it or heard talks on Rule 1.2, we often talk about the ends and the means, and Rule 1.2 mentions that you have to abide by the client's decisions on the objectives. B, which I didn't include here, says, nevertheless, you will consult with the client on tactics. So goals are the client's to determine, such as settlement, proceeding with the suit, and so on. Tactics, that is the means of how you carry out your practice. Those are for you to decide, but in consultation with your client. Now, if those are the basics of Rule 1.2, C gives us a qualification, and it says, you shall not counsel a client to engage or assist in conduct that you know is criminal or fraudulent. Now, who is that there for? Obviously, if the client wants to do something, they think it's to their benefit to want to do it. But what you have an overriding obligation to see to it, and it's mandatory, that you will see to it that they will not commit fraud or a crime as long as you are working with them. You will not participate in that or encourage it or help them. Rule 1.3, diligence. This is a sweet little rule, and it really says simply, a lawyer shall act with reasonable diligence and promptness in representing a client. I've summarized it here in the slide. Now, comment, so we know what that means is you can't put off talking to your client, you can't fail to communicate with your client, you can't stall your client, and you can't refuse to keep projects moving. The ethics officials in Lincoln, Mark Weber and others, will tell you that one of their chief complaints that they get is, my lawyer doesn't seem to be working on my file. What's going on? So diligence is a responsibility you have to keep your client happy and to keep the client's case moving, whether it's litigation or otherwise. Now, comment 1 says, your duty of diligence does not require offensive tactics or preclude you from treating others with courtesy and respect. It's not mandatory, but it's pretty strongly worded. and the way it's worded is, it's pretty clear the expectation is you're not going to be rude to others in the course of zealously representing and diligently representing your client. And your duty to act promptly, which is part of diligence, doesn't preclude you from agreeing to reasonable requests for postponement. So if the other side calls and asks you to put off a trial, a court date or a deposition or something, you are not precluded from agreeing to that. And that's part of the tactics that you get to determine. So I think the easiest way to deal with that is the golden rule. If you would expect some other attorney on the other side of a case to accommodate your request for a postponement, you ought to do it for them. Confidentiality. Now we know this is one of the big rules. This is one of the main ones. And we know that the confidentiality rule is there to protect the client. That is, the client is entitled to absolute confidentiality of what they share with you. You shall not reveal information. That's mandatory. However, there's an exception under B that says you may reveal. It doesn't say must here. This is the Nebraska version. You may reveal information that would otherwise be confidential to prevent the client from committing a crime or harming someone, certain death, substantial bodily harm. Comment 6 says, there is an overriding value. Now that value goes beyond the client. It overrides the client. And that is the value of life and physical integrity of others. So there's a duty that overrides, although it's stated as a permissive duty, you may reveal. So let's look at the Iowa version of this rule, which is slightly different. See if I can pull that up. B says you may reveal, B1 under Iowa is the same. You can reveal information that would otherwise be protected to prevent reasonably certain death or substantial bodily harm. But then 2 and 3 are new under Iowa. Nebraska hasn't got them yet. And that is, you may reveal confidential information to prevent, mitigate, or rectify. So that's either future or current or past financial damage caused by the client using your services. Now, there's a catch there, and that is, are they using your services? So let's say you've prepared some documents and you find out later that that behind those documents is a fraud that the client is committing, and they're using your services in those documents to commit the fraud. That's when you may step in and either prevent the harm from coming or even go back and rectify it. Now, Iowa goes on to say that you shall reveal imminent, that is, you shall reveal confidential information to prevent imminent death or bodily harm. So it goes beyond permissiveness in Iowa to a mandatory rule. Conflict of interest. Now, if you think about it, the conflict of interest rules are really there where there's always another party involved, aren't they? The conflict of interest rules, the entire rule takes into consideration someone other than your client. If it's just you and the client, there's nobody else out there to have a conflict with. So the conflict of interest rule is pretty straightforward, and we do look at it frequently. And that is, you may not represent a client if it's adverse to another one of your clients, or you are limited by some duty that you may have to another person. And Rule 1.9 gets a little complicated, but it goes on to explain your duties to former clients. The conflict of interest provision is not quite as strong with regard to former clients, but it's still out there. So the point of this is just to remind you that the conflict of interest rule is definitely set up with other people in mind. Rule 1.13, the organization as a client. So think of it as a company, think of it as a corporation or partnership or something. The point of Rule 1.13 is that when you represent a company, obviously it's a piece of paper on file with the Secretary of State's office. It's a legal person, but it's a piece of paper. So who do you talk to when you're representing an organization? You talk to one of their officers, the owner in a partnership, maybe the partners or shareholders or directors or officers of a corporation. So you represent the entity, but it is acting, and A goes on to say you represent the organization acting through its duly authorized constituents. Well, what happens then is that a person who represents the company think of themselves as your client, clearly. And we've all worked with entities, and we know that they're the ones we're talking to. They're the ones who call the shots, make the decisions, and so on. So they tend to think of themselves as a client. Well, Rule 1.13 warns us as lawyers that there may be a time where those constituents have some kind of personal conflict with the company. So let's say you've been dealing with a vice president of an entity, of a corporation, and you find out that they may be on the way to harming the company. They may have some kind of personal interest in something they're doing for the company, and that may represent a conflict of interest for them. So Rule 1.13 tells us under F that you have to explain to those people who the client is. So it says in dealing with officers and directors and so on, you shall explain, it's mandatory, you shall explain the identity of the client. Hey, I represent the company here. And you need to make sure that you tell them that you're not representing them. Comment 10 goes on to say that you have to not only tell them that you're not their personal lawyer, but you may want to tell them, it says that they should get their own counsel. There's a case from the US Supreme Court called Upjohn, which refers to this as a corporate Miranda warning. Look, I think you've got an issue here between you and the company. You need to know I'm the company lawyer, not yours. You should get your own attorney. It does say that you have to take care to understand that the individual understands that there is that conflict of interest going on and that you can't represent the individual. Now, back up for 1 second and understand, especially when we work with smaller clients, smaller company clients, we often do work for the individual and the company. So we're representing a mom and pop partnership with several partners, and we're doing work for the entity, fine. You know, the entity enters into a contract with a third party, fine, we represent the entity. Then mom and pop call us up and say, can you prepare a will for us? Or, you know, one of our kids just got a traffic ticket and we want to contest it, can you help out? And so on. So it's just natural that you will do work both for the individual constituents, even in a larger company. Vice president might come to you and say, look, I need some help. I'm buying a house. Would you look at the papers? That's natural. That doesn't involve a conflict of interest. The only time you have to back off from that individual and warn them that they're not your client is when their activities puts them in some kind of conflict of interest with the company they work for. Safekeeping property. Now, Rule 1.15 has to do with setting up a trust account for the money that we're holding for a client. We know those are very detailed rules, very extensive rules. We also know that those are automatic tickets really to disbarment if you misuse client funds that you're supposed to be holding in a lawyer trust account. So we hear a lot about that because of the details and our concerns that we do it right, because nothing will get you in hotter water than messing up proper handling of client funds. So when we think of a trust account and safekeeping property, and by the way, the rule goes beyond just money in a bank account. It's any property of the client that you're holding. We tend to think of it as between us and the client. But look at what D tells us. D says, upon receiving funds or other property in which a client or third person has an interest, the lawyer shall promptly notify the client or third person, and then you have to promptly deliver the property to that person, whether it's your client or that third person. So you may receive money that's supposed to be dispersed to someone else. You have to notify them and promptly deliver it. Now, E says that if you've got somebody claiming proceeds, somebody claiming money that you've received, that you've put into the client trust account, and you have a creditor of your client that comes in and says, that money goes to us, then you have to sit on it and keep it separate, and you might interplead it to get it out of your own hands and into court, but you've got to hold it then until the dispute's resolved. Now that process of holding on benefits your client to make sure that somebody else doesn't get their money, but it also benefits the third party so that the client doesn't take off with money that rightfully goes to them. Duties to a prospective client. Now, this is a relatively new rule in the canon, and it arose from the fact that lawyers often meet with people to discuss the potential of representing them and then decide not to do the representation. Now, sometimes a prospective client decides they don't like you and they'd rather go somewhere else. Fine. But you may look at them and think, look, this isn't my type of case. I don't do personal injury. I thought this was a business counseling thing, so I don't do personal injury. I'll help them find somebody else. Or as often as not, you may find out that the potential client is in a conflict position with you. So if you have a good intake system, and if you're sensitive to this, and if your staff are sensitive to this, you're going to have a good conflicts checking system. And when somebody calls to make an appointment, you may want to do an initial interview over the phone and find out who the other parties are to the dispute, run that conflicts check. The other thing is when you're meeting that person, say face to face, thinking you don't have a conflict, and you start to talk to them and suddenly something comes up and you think, wait a minute. Now you hit pause, and you're going to break up the meeting, go do your further conflicts check, or you just know at that moment, and you say to this person, don't tell me anything more because we've got a conflict. Now, that prospective client who never becomes your client is a third person. And Rule 1.18 spells out specifically that you have duties to that prospective client, that person who doesn't become your client. You have responsibilities to them. Well, one of the duties is under B. Even when no client-lawyer relationship ensues, a lawyer who has had discussions with a prospective client shall not reveal or use that information that you learned in the consult, except 9 would permit with regard to former clients. Now that gets a little complicated and we don't have time to go there. But basically, even if a person's not your client, they're a third person, so to speak, they become a quasi-client because you have confidential information about them that you can't use. C says that subject to paragraph B in terms of not using or revealing information, you may not actually take on a matter adverse to that person because you've learned too much from them. So you get conflicted out. You can't use that information. You can't be on the opposite side of that case. And that conflict there is imputed to your law firm. D tries to help you out a little bit. Sub D says, if you've received disqualifying information from this prospective client who you turned down, you may represent someone else against them if, well, both the actual client and this prospective client give consent. Well, that's never going to happen. That's often in the rules, and you know that's not going to happen. But you may represent someone against that prospective client if you took reasonable measures to avoid exposure to more disqualifying information than was reasonably necessary to determine if you had a conflict. Now, if you've done that, you still have a problem, but your law firm may be able to take the representation against that prospective client, and you have to be screened out. So if you find yourself in that awkward situation, this is not a simple little rule. There are details, and I would advise that you look carefully into Rule 1.18 to see if you are precluded from, you or your partners in the firm are precluded from going forward. Okay, now we're, so that's as far as we've gone in section 1, which is the attorney-client relationship. And we've seen various points at which our responsibilities to the client are tempered by broader concerns for other people. Under section 2, under part 2, and it's really not much in part 2, but I do like Rule 2.2. I did a lot of transaction work in my practice years, and I was in many transactions, one lawyer or the other was writing a legal opinion for the opposite party, a third-party legal opinion. I represented a lot of banks making loans to companies, and we would then get a legal opinion from the borrower's attorney as to the corporate existence of the borrower and proper steps being taken by the borrower to borrow the money and so on. Well, think about that. That legal opinion that I was getting from my bank, that legal opinion was coming from the borrower's attorney for the bank. That is a legal opinion to the bank. Now, you know what a third-party legal opinion is, but think about what an odd duck it really is. The lawyer on the borrower's side is zealously representing their client, trying to get them the best deal possible, negotiating the wording of the documents, moving the transaction along to closing, and so on. At the same time, now they're going to deliver a letter to the opposite party, the lender, to try to help move the transaction along and to make it more enticing for the lender to close the deal. Fascinating, what a position that puts you in. And I will tell you that in some very large transactions, almost half of the legal work for me as lender's attorney or attorney for one side in a different type of transaction, almost half of my work was spent arguing about legal opinions. Because again, in a financing, the bank wants the strongest possible legal opinion, including those dreaded words for the issuer of the opinion that the loan agreement is valid, binding, and enforceable in accordance with its terms. That valid, binding, and enforceable opinion, or the enforceability opinion, if you will, causes lawyers giving these opinions to lose a lot of sleep. But there you are as a lawyer providing a legal service in a way to somebody who's not your client. In fact, somebody who's on the opposite side of the table from your client. Well, Rule 2.2 says, giving an evaluation of a client matter for a third person is permitted. This happens in various contexts, but as I said, I was a transaction attorney and I saw those frequently. So you may do that. The rules permit it. However, B goes on to say that you may not give adverse information, that is information adverse to your client, unless the client consents. Well, let's say there's some internal information about your client that they want to hide from the bank in this, when you're giving the legal opinion, and you're giving the legal opinion, that's a problem. Because then if the client says, no, you can't reveal that, and you say, I can't give the opinion unless I reveal that, I'm not going to participate in hiding the ball. Well, then you've got to back off. You've got to get out of that transaction. You've got to refuse to give that legal opinion. And then, of course, you've raised a red flag, and the lender will figure out what's going on. Fascinating here to me, and maybe I use fascinating too often, but comment 3 says that when you give one of these evaluations to a third person, and I'm thinking in the framework of legal opinion, when the evaluation is intended for the information or use of a third person, listen to this, a legal duty to that person may or may not arise. That legal question is beyond the scope of this rule. The comment then goes on in detail and talks about the ramifications of your duties to your own client in giving the legal opinion. So beyond the scope of the rules don't tell you what your responsibilities are to that third person. And then I think that throws us into the realm of misrepresentation, some kind of third-party fraud, tort, or something like that. And of course, lawyers argue endlessly about the meaning of an enforceability opinion and the liability of the lawyer giving the opinion. Is that covered by your malpractice insurance? Do you actually create a duty between yourself and that third person? So that's a fascinating one that deals with how you interact with third persons and how you may have a duty to them. And by the way, I'm certain you do have a duty to them in giving that legal opinion. You're signing your name to it. All right, let's go to advocacy. That's part 3 of our rules of professional conduct. 3.1, meritorious claims and contentions. Think also of Federal Rule 11 or any rule of procedure requiring good faith on the part of the attorney. 3.1 uses the same language, and that is you may not make frivolous claims or contentions. You shall not bring or defend a proceeding or assert or controvert any issue therein unless there is a basis in law and fact for doing so that is not frivolous. Now, you can also make a good faith argument that the law should be changed. Comment 1 brings it straight down to the client versus the other person. You have a duty to use the legal procedure for the fullest benefit of the client, but there's your countervailing duty, a duty not to abuse legal procedure. Comment 3 gives a more relaxed standard for defending criminals in criminal defendants in criminal proceedings, and fighting. You can fight a little harder to ensure their constitutional rights. It doesn't say you can bring frivolous defenses, but it sort of moves you in the direction of a lot less of a stringent standard. Interestingly, there was a case in the 7th Circuit called Manistee Apartments that said that the test for disposing of identifying, this is for the court, to identify and dispose of frivolous claims under this standard or Rule 11 might be where we suspect, this is the 7th Circuit speaking, where we suspect that lawyers rather than claimants are the only potential beneficiaries. And this gets me into one of my pet peeves is these class actions where you get a notice that, dear customer of somebody, X Corp. We understand you purchased some services or products from X Corp at some time in the past. Well, we found out that you've been overcharged, and so we've started a class action. If you fill out this form, you'll get your share of the proceeds. So then, 6 months later, you find out there's been a $100 million settlement with the client, with the defendant. $100 million, the plaintiff's attorneys walk away with a third of that, and you get a check for $7.15. And that's the sort of thing that the Seventh Circuit may be thinking of. Is it only the lawyer who's going to benefit from this process? Anyway, sorry about that cynical observation. Rule 3.2, expediting litigation. And I've summarized it in the black letter there, but it says, in the lawyer's representation of a client, a lawyer shall not file a suit, assert a position, conduct a defense, or delay litigation or take other action on behalf of the client when the lawyer knows or when it is obvious that such action would serve merely to harass or maliciously injure another. Now, when you use words like maliciously injure another, obviously, you're not going to be allowed to do that. Comment 1 kind of brings us maybe to our senses a little bit and says, why are we talking about this sort of thing? Well, listen, comment 1 says that dilatory practices. Now, we're not talking about malicious practices or harassing practices necessarily, but when we talk about delaying, not expediting litigation. Comment 1 says, dilatory practices bring the administration of justice into disrepute. Now, obviously, dilatory practices harm that third party. We're talking about 3D chess here. That third party, that is the person on the other side of the case. But dilatory practices also hurt the entire system of justice. There's some odd language a little later in the comment that says, it is not a justification that similar conduct is often tolerated by the bench and bar. So if people stall and the judge doesn't issue sanctions, the rule here, or at least the comment, is saying that doesn't make it right. Well, if the court's not going to do anything about it, I doubt you're going to be disciplined if the court doesn't care. So you shall not do things that have no other substantial purpose except to delay. So expediting litigation, you're protecting the system, you're protecting the party on the other side. Candor to the tribunal. I think this is in a similar vein, Rule 3.3. Rule 3.3 breaks down, and these are all mandatory. You shall not make a false statement of fact to, it says make a false, this is under A, 1, 2, and 3. I didn't list them here. A says, you shall not make a false statement of fact to the tribunal or fail to correct one that you later realize you made incorrectly. And you shall not fail to disclose relevant law that's applicable in the jurisdiction that the other side hasn't raised. You don't have a duty to disclose relevant facts, but if you're aware of case law that goes against your case and the other side hasn't raised it, you have a duty. And you shall not offer evidence that you know to be false. Okay, so that's part of A. Who are we protecting here? Well, I guess broadly speaking, the system of justice, but we're certainly protecting the other side because those false statements and so on are going to possibly help you win your case to the detriment of the other side and unfairly. Part B says that if you find out that your client is committing criminal or fraudulent conduct, you shall, it's mandatory, take remedial measures, including, if necessary, disclosing it to the tribunal. Again, you're benefiting the other side in the case and you're protecting the integrity of the process. Those duties are there even if contrary to Rule 1.6. So you find something out about the client lying in court, you find that out, well, that's confidential. That's under Rule 1.6. But this Rule 3.3 actually overrides Rule 1.6. Those duties under A and B apply even if compliance requires disclosure of information otherwise protected by Rule 1.6. The last part then, D, talks about in an ex parte proceeding, you have to be very careful to disclose adverse facts. Now, when you have a represented party in court, you don't have a duty to disclose adverse facts. You may not lie to the court, you may not have your client lie, but you don't have that duty. But in an ex parte proceeding, the judge is relying on you and the system relies on you, and as well you're protecting the other party. Words that are among my favorite in the rules here come in comment 2, and I'll just read them. Actually 2 and 5, but I'll read you from comment 2. This rule sets forth the special duties of lawyers as officers of the court to avoid conduct that undermines the integrity of the adjudicative process. So there you have it. Let's go to Rule 3.4, and in the interest of time, I'm going to go through this one quickly. Rule 3.4, and litigators know this one quite well. You may not obstruct access to evidence. That protects that third party. You may not make frivolous discovery requests or fail to comply with them. That harms the other side. And so this rule protects, it's the process, but it tries to make the process fair for everyone. And comment 1 says, fair competition in the adversary system is secured by these prohibitions. So the adversary system still doesn't just mean you go all out for your client. You have to be zealous, but you have to play fair. And comment 2 talks about discovery and exchange of information through discovery as an important procedural right. Decorum. Rule 3.5, no improper contact with a judge or juror, no disruption of the tribunal. Comment 4 explains that your function as an advocate, you have a license to stand in front of court and advocate. Your function is to present evidence and arguments so that the cause may be decided according to law. You have to refrain from abusive or obstreperous conduct, which would impede the fair decision on according to law and procedure. Trial publicity, again, as part of your duty as an advocate, playing in a set of rules that are there to provide fairness. You have to avoid prejudicing a case through your extrajudicial or extrajudicial statements. Comment 1 says, if there were no such limits, that is, and Rule 3.6 does have some detail in it. If there were no such limits, the result would be the practical nullification of the protective effect of the rules of forensic decorum and the exclusionary rules of evidence. I like those words, forensic decorum. We think of you litigators as advocates, as zealous advocates, vigorous advocates, but you are bound by the rule of forensic decorum. All right, Rule 3.8, special duties of a prosecutor. You can only bring a case if you believe it's supported by probable cause, and you have to make sure that the accused has a chance to be represented, and you have to disclose all evidence. Now, some of my other favorite words here, and remember, we're all officers of the court. We got that. But I love these words. A prosecutor has the responsibility of a minister of justice and not simply that of an advocate. There you go, prosecutors. You are ministers. truthfulness to others. So we've got a couple of rules here in part 4, which is called transactions with persons other than clients. So you represent a client, but you're dealing with other attorneys and other people. Rule 4.1 says, in representing a client, you shall not knowingly make a false statement of material fact to a third person. You're protecting that third person by not being allowed to lie to them. And you shall not fail to disclose a material fact if failing to disclose it would be assisting, say, your client in criminal or fraudulent conduct. It says unless disclosure is prohibited by Rule 1.6, then you have to go back through 1.6 and see if this information or this upcoming crime or fraud is an exception to Rule 1.6. Comment 1 says that you don't have a general affirmative duty to inform the other side of relevant facts. Our litigation system, our adversary system, assumes both sides are individually, separately marshaling the evidence. We do have to inform the court of adverse law, but not the other side. We don't have to give them facts. We can't hide the facts. Comment 2 talks about leeway in negotiations, where you can fudge on the truth a little bit in negotiations. Good luck on that. It refers to under generally accepted conventions in negotiation. My negotiation expert friends say there are no generally accepted conventions, but I guess you get to fudge a little bit by saying, oh, my client would never accept that, when that's not true. Dealing with a represented person, we know that if a person is represented, this is just there to protect that person. We can't talk to them. We can't talk to them, and they can't even consent. Their lawyer has to consent if we're going to talk to them separately. Now, hopefully we don't do that very often, but we have to be very careful about that. So that rule is definitely there to protect that other person from you. And why? It says, this rule contributes to a proper functioning of the legal system by protecting a person who's got a lawyer against possible overreaching by other lawyers. So this rule is absolutely there not to protect your client, but the other client. There are details about communication with the constituents of an organization, and there's lots of details out there on that in terms of when you're gathering evidence for a lawsuit against a corporation, which people at that corporation, and the corporation's got lawyers, which people may you contact without informing the lawyers for the company. The details are in the rule. I think my last one, no, 2 more to go. Rule 4.3, dealing with an unrepresented person. I think this one's fairly straightforward. You're representing a client, and the party on the other side of the transaction, if that's what it is, chooses not to use a lawyer. Lots of people do that. You may communicate with them, but be very careful not to give them legal advice. You may not act as if you're in the middle of the thing if you're not. You have to make it clear who your client is. You may not imply you're disinterested. And the only advice you can give that person is to get a lawyer. Now, obviously, if you're in that situation, that person thinks they're sophisticated enough, so you're going to say how you're going to handle the transaction. Yeah, we do it this way because you have to, the regulations require us to prepare this type of document and file it and so on. Well, are you just stating what you're doing, or are you actually giving advice to that other person? You just have to always make sure that they don't start to ask you for advice and you give it to them. But now, once you've disclosed, you may negotiate because they choose not to have a lawyer. Last one here is respect for third persons, rights of third persons. And this is a broad rule. It says, in representing a client, you shall not use means that have no substantial purpose other than to embarrass, delay, harass, or burden. We saw this back in part 3 of the rules. So your responsibility to the client in the comment 1, your responsibility to the client doesn't imply that you may disregard the rights of third persons. And to me, this sums up where we are. You have responsibilities to your client, but along the way, you may not disregard others, whether that's the court system, the public, or the other client. And so we end up back with Star Trek, and in the Star Trek movie called The Wrath of Khan in 1982, Spock was about to sacrifice himself to save the crew of the Starship Enterprise. And Captain Kirk says, why would you do that? Why would you go into that radioactive thing, engine room, and why would you go in there and sacrifice yourself for the rest of us? Because the ship would explode otherwise. He says, Spock says, the needs of the many outweigh the needs of the few. And I think here we are. The few are your clients, the people you represent, but sometimes the needs of the public and the other side will outweigh your responsibility to your clients. So there we are, folks. That is a quick walk through the rules. I hope you have enjoyed this presentation. I found it fascinating to see how many different flavors this one concept has. And I thank you for attending this seminar virtually, and I wish you the best.
Greetings, everyone. I would like to thank the Omaha Bar Association, Creighton University School of Law, and specifically Dave Sommers with the Omaha Bar, Professor Sieberson, and J. Scott Paul, my partners in presenting to the Omaha Bar Association today. Also, to save a little time, we're also recording this session to the Creighton University School of Law, Professor Daniel Reel's summer professional responsibility class. Then finally, I'd like to thank my colleague and co-presenter, Chris Opperly, with the Nebraska Lawyers Assistance Program, NLAP, for his contributions to what we're doing here at Discipline and how we're trying to make the whole disciplinary process more user-friendly. As you see, my first slide was not your parents' regulatory agency. And I think that's one of the things I'd like to do is change perceptions, whether I'm speaking to the law college or to my colleagues out there in the trenches practicing law. I usually introduce myself as I'm Mark Weber, your Nebraska Supreme Court Counsel for Discipline, and I want to be your friend. That's usually met with nervous laughter out there, but I am serious. And believe it or not, I've been in this position for nearly 6 years now. It'll be 6 years Labor Day weekend. It's amazing to me how the time has flown by. I'm very grateful for all of you for including me, welcoming me to speak to groups such as the Omaha Bar Association and also to the law school. When we talk about not your parents' disciplinary office, I have to say that unfortunately this is what the perception is about discipline and what we do, and we're really out to change that. In the few minutes that I'll be with you today, I really do want to emphasize that what we're trying to do here is let you know that we would rather pursue education than prosecution. That's why we do what we do with outreach. That's why Chris Opperly and I get out there. You'll see the slide here. PMBR, my mug might be in the way, but it's proactive management-based regulation. I like this quote from Einstein: education is what remains after one has forgotten everything he learned in school. Is not the truth. You know, true education, those things that you learned in kindergarten, as Professor Fulgram would say, everything I needed to know about life I learned in kindergarten. You know, be nice to each other, pick up after yourselves. More importantly, in these crazy times, don't forget to take a nap. But some of the things, this nice illustration here, what would you rather do? What fits your busy schedule better, exercising 1 hour a day or being dead 24 hours a day? I think it fits with proactive management. We'd rather that you focus on your skills as a practicing attorney and also focus your eye on the ball for ethics and professionalism in your practice. And with that, we'll all get along. We're here to help. We're a resource. As you know, you can call us. Specifically, call me anytime. I'm here to help. Do it while you can. I have to caution that Iowa just recently passed a rule, believe it or not, that prohibits counsel from calling the disciplinary office. The American Bar Association, when they audited my office, they frowned upon our taking calls. The thought being, believe it or get out of town, that we're so litigious that you're going to use a call with me as a defense to a future prosecution. You know, I say when I speak, good luck with that. You know, I'd like to, let me know if you're going to stand up in front of the Supreme Court and say Weber said it was okay to borrow from the trust account. That's clearly not okay. We all know better. Unfortunately, with time permits, we're going to get into, as hard as we try with this proactive management-based regulation to educate, there are always going to be some who cross the line intentionally, negligently, recklessly, and discipline must follow. So we may, if time permits, go through a few examples. But the future of regulation, I talked about it, education before prosecution. You know, what we're trying to develop, and many states are now in the process of developing them, is a self-assessment exam that covers anything from trust accounting, conflicts checks, and I need to add to this slide, it also includes a wellness element, and that's where Chris comes in, and with NLAP, and his loyal following, the people on the board. It's much like the underwriting process when those of us go out and seek malpractice coverage. What are you doing for calendaring? What are you doing in conflicts? What are you doing in your trust accounting, backup systems, redundancies, etc.? So generally speaking, attorneys and firms who have malpractice insurance are exempt because they basically have gone through the process. But what we're in the process of developing here is this self-assessment exam. It'll be computerized. It'll take about 4 hours, but you can do it in increments. The good news is you'll get some credit in addition to reflecting upon your practice, what you're doing well, what challenges are in terms of your practice, and then we will provide links for resources, whether it's through attorney services, specifically with us at Discipline, with Trust Account School that we're going to implement, or with well-being assistance through NLAP. We're working on that. So we hope to have something launched on that here within the next few years. Now, this is something that is critical to what we think will make this work. If you're participating with us and acknowledging that you need assistance and you're seeking that assistance, it will provide you some level of immunity. No, not for stealing from the trust account. No, not for having relationships with a client during the representation. But you get it. If you have some errors in your trust accounting, we're not going to come after you. So again, we're providing this as a service, but it's to avoid discipline. As I've said oftentimes before, the Supreme Court doesn't reward me for bringing cases before it and accruing a bigger number of overall discipline. We are there to help. Unlike the old adage, I'm with the government and I'm here to help. I think that was Ron Reagan's mantra that everyone kind of chuckled at. So some of the things, there was an audit of NLAP several years ago, just like the one that I told you about, where they were frowning upon our taking your calls. One of the other things I should mention that they indicated was that we just don't do enough on auditing of trust accounts or discipline in trust accounts. You'll see if we get there the recent examples of some of the cases we have prosecuted in trust accounting that I would beg to differ with them saying relax on that. But we work on alcohol drug dependency issues. I will say that, you know, Nebraska stands out. We were one of the leaders thanks to Rick Allen and the wonderful crew that he has assembled over the years that he passed the baton off to Chris Opperly. But also my office is taking steps that if we see a drug-related offense, and we know the media likes to report on lawyers who make mistakes, that we reach out to offer our assistance. We have implemented a diversionary type of program that if there's an alcohol-related offense out there, we may not pursue discipline, and we probably won't, for example, on a first offense DUI, but we are going to make a very sincere appeal to the individual to seek assistance through NLAP, waive confidentiality so Chris Opperly can refer back to me and say this person is with us, we're taking care of it, and then also let us know when he's discharged, or more importantly, when he fails. So those are some things we've been working on for the last several years. So we're also focusing with Chris Opperly and NLAP, growing issue among our practicing attorneys, issues with aging, disability, impairment, and diminished capacity. Sadly, this is only going to increase. We also, as I discussed, we are increasing our discretion with respect to lower level offenses. I know the argument out there, if you look at the maintaining the integrity of the profession rule, it does relate to crimes being committed by attorneys, but you'll see in the comments, interestingly, that the focus is really on issues of moral turpitude, trust issues, dishonesty, things like that. And some would argue, and maybe successfully, that a first offense DUI is none of our business. Nonetheless, the American Bar Association says most states are going to some investigation into these relatively minor offenses, because we've seen a trend that where there's a problem in that area, it may lead to problems with practice. So again, what we're trying to do is intercept a potential issue to protect your clients, which is one of the reasons we exist, and also to assist you to keep you practicing, to avoid serious impairment, and avoid you losing your ticket to practice law. So we talked about the diversion and probation issues. We want to continue with that and expand that if possible. I told about waiving confidentiality. If you complete the program, it goes away. It's a win-win. We don't open a file. You don't have it on your permanent record when you seek reciprocal admission in another state, or more importantly for many of you, when you seek to move on up to the bench and apply for a judicial vacancy. We would report no, although I must caution you, you will still have, of course, the requirement in either the reciprocal admission or wanting to become a judge. You're obviously going to have to report any criminal convictions. But at least it's one less thing that you have to worry about with respect to the Counsel for Discipline. So I would only prosecute you if you failed, as I mentioned. And then one of the issues now, we'll move on quickly here because I'm limited with my time with you today. We just want to provide support for these issues, you know, that these are common issues that we all face, you know, billing practices, terminating relationships with our clients, conflict issues. Those are probably the bulk of the calls that I receive are on conflicts. And I'm no genius when it comes to determining conflicts. I always say, and I haven't had a judge come back to me yet, deal with it in the case in which you find yourself. If you're not in litigation yet, document. Mr. Opposing Counsel, I don't see how you can represent your client given your prior representation of his soon-to-be ex or whatever issue. Document. If attorney respectfully, and I hope the attorney would respectfully disagree, or I should say I don't hope that they disagree. I hope if they do disagree, they do so in a respectful manner. There's a big difference there. That they would provide you with perhaps some authority for why they are going to stay in the case or the real estate transaction, what have you. But if they do disagree with you and you feel very strongly that it is a conflict, then bring it up with your judge. The judge will resolve it. and we may talk, time permitting, about potential conflicts, perceived conflicts, and real conflicts. Perceived conflict, you're going to hear a judge say, well, I don't think it's a conflict either, but I don't want the optics of this don't look good, and I don't want the Court of Appeals to send it back, so I'm going to ask you to get out. That's not a true conflict. That's just a perceived conflict, and the judge is trying to avoid seeing the case come back. Records management, that's really being assisted with technology, and our advisory committee has told us that we can now, first back in the 80s, we can't say when you can get rid of your client file because it depends on the nature of the case. And finally, our advisory committee, evolved with technology and said, well, that's ridiculous. Of course, there has to be a time. So we said, just like business records, you may destroy your client files 5 years from the date of the end of the representation. Of course, I would say, no, make it easier on yourself and get rid of these files and records and make it the client's burden to accept the file at the end of the case and receipt for it so you're done with it. Now, the technology has evolved even further. We're scanning those documents so we have them anyway. Best practice, scan them the day you get them, unless you need that original for an exhibit. And I'm suggesting that I think our court rules and laws will catch up with technology and we can use copies. That's going to evolve. Bitcoin sounds foreign to many of us, but even the whole idea of blockchain technology can provide verification for documents that we won't need to keep those originals, and we don't want to keep the original wills. But now we've even gone further. In addition to being able to scan, we're now saying you can file your records into the cloud, and so you don't even have to have that data storage on site. So these are just a number of things that you look for that allow you to make your practice easier, less of a burden on your partners, perhaps, unfortunately, a spouse if you were to pass or become disabled. We don't want those records lying around. Good use of our time, especially for you law students and younger lawyers out there, not being caught up on these returning of phone calls, picking a couple times a day, 10 o'clock and 3 o'clock, when you return your calls, relying upon technology, emails, text messages, your legal assistants, make you look good every day. Be responsive, even if it's not you directly, but use technology to make you more efficient and make your life easier. Supervision of staff. I mean, how many times are law students as law clerks being sent out to interview witnesses? Attorneys, have you educated those law students? Law students, have you educated yourself on the rules associated with dealing with the unrepresented person? Attorneys, your law clerks are your agents. You cannot have them go out there and act neutral when clearly they are not. So you have to be honest. And yes, I know the cynical attorneys saying, well, that's great advice, Weber. I go out there and have my clerk interview a witness and provide all these disclaimers about how they work for a lawyer and how it's heading to a lawsuit and how we hope to win. And then the person's going to slam the door in our face. Well, that's the reality. We cannot imply that we're disinterested when we're not. And then trust account. I mentioned briefly the American Bar Association said that we're wimpy. That's a technical legal term. We're wimpy when it comes to supervising our attorneys with respect to trust accounts. I challenge each of you that is practicing or in a firm where there's a financial partner, a financial manager. Would your trust account zero out? Are there old accounts there with client funds that have been there for years collecting dust and you haven't gotten rid of them yet? I challenge you. I would hazard a guess, as frightening as it is, that most of us, greater than half of us, have got issues in our trust accounts that we are not aware of and we're just putting our head in the sand. So don't make me come there. The ABA wants us to do random audits. I don't want to do random audits. I don't have the budget to do a random audit. And frankly, let's be honest, the random audit isn't going to catch the dirty double dealer that is hiding funds or dipping into the trust account for personal use. So a few statistics, give you an idea. That's a hot issue right now, especially with the COVID. You know, of course, our discipline has slowed with the COVID-19 shutdown. Our actual prosecution cases have slowed because of the frowning upon in-person meetings. So I think that's a little blip on the continuum here, but yes, overall, our numbers are down. You'll see the numbers going back to 2011. Mandatory continuing legal education, by the way, was mandated in 2010. As you can see, we didn't have room on the charts, but as you can see from 2011 up to 2016, the numbers steadily declined for overall complaints, and that's the yellow bar in the background. The very formal serious complaints are in front. The summary dismissals that I basically grant summary judgment are in the orange, and then the 9C or preliminary inquiries follow in the gray. You'll say, well, Mark, why such a jump from 2015 to 2016? Well, that's simple. We added our case management system, which did a better job of collecting data and counting complaints. For example, in some cases, in the older days, we might have had a complaint in a criminal case against the judge, which we don't have authority to investigate anyway, against the prosecution, against the defense attorney. Well, that may have been counted as one, whereas today that may be counted as two: complaint against the prosecutor, complaint against the defense attorney. My guess, and I was proven correct as you can see from the chart, is that going forward from 2016, we would see a steady decline in cases, and that has basically been true, holding steady really the last few years. And for some reason, I don't see the data here, but first half of 2020, you would see that our numbers are fairly consistent at the 6-month mark. The formal grievances are way down, but again, I think that's attributable in part to the COVID shutdown. And the overall grievances are roughly about 50% of what we would expect for the full year. So I just received this morning, as a matter of fact, a survey of disciplinary chiefs across the country. Numbers are overall down, but I think you will also hear that while overall complaints against attorneys are down, our numbers of attorneys, practicing attorneys are down. But there is an argument to be made that in spite of the decline in numbers of complaints, the complexity of the complaints going forward to prosecution and trial are much more complex than they would have been, say, 10 years ago. Length of practice, very interesting. Most of our complaints usually, as you can see here, are for those of us that have been practicing, 20 years or more, account for more than 50% of the overall complaints. Congrats to you future lawyers down there at Creighton Law. A couple of years ago had 0, but still a small percentage, all things considered. Really a reversal, I must say, looking back 6+ years ago, going into this job. I assumed it was you young lawyers that were the ones getting in trouble. The seasoned veterans knew better, knew how to avoid the pitfalls, and I figured I'd be spending my time with you hotshots coming out of law school, thinking you knew everything or were too proud to go ask for assistance. And frankly, there are more of the law students going out into solo practice, which has its own challenges and blessings. And one of the challenges is that you don't have mentorship. So anyway, my apologies. You've proven me wrong. And my challenge to those of us that may have been out there a while practicing, why are we getting more of the complaints? Are we failing to pay attention? Are we failing to continue our legal education to enhance our skills and our practice and keep sharp? The best excuse I heard was from a gray-haired attorney, raised his hand and said, I'll tell you why. The more experienced attorneys get the more serious cases. There's more at risk. The higher asset divorce, the bigger estates, the more serious felonies. And those are the ones when life and liberty are at stake those are the ones that are going to end up, you know, in a complaint with our office, rightly or wrongly. It's just a fact. Pretty good response from this attorney, and I think he may be partially correct. So area of law, again, the chart, I don't know if it's inhibiting here with my recording and my video, but criminal, domestic relations, trust and estates are really up there, as I said before. When you're talking about life, liberty, and property, you know, when I first came into the office, we only had about 4 categories, really didn't tell us much. Now, maybe you'd say that's too much data. We actually have moved this out to a line chart to give you a little better sense of what this all means. But you see criminal by far is off the charts here. And for those of you that are practicing the criminal arena, criminal law arena, obviously, you know, you're getting complaints. I was nearly 30 years in private practice, always did a bit of criminal defense representation. The good news is if it's a court-appointed case in juvenile or a criminal court-appointed counsel, and I conversely add prosecution in this, I don't investigate these. By court rule, I'm not to get involved with ongoing court-appointed counsel in criminal cases and juvenile cases, and that's for a reason. The context, the theory behind it is you should deal with it within the context of the ongoing matter, bring it up to your trial judge, or it's a matter for post-conviction. Domestic, of course, is up there, very intense area with a lot of dissatisfied parties. As those of you who practice in the area of domestic relations know that neither side is going to be happy no matter what the result. And then the list goes on. And if you are interested in obtaining these statistics or my slides, just reach out, give me a call, and I'll be happy to send them to you. Types of grievance, again, the chart is somewhat obscured here by our technology, but neglect is a big one. And my predecessor, Dennis, who was there, Dennis Carlson, for, gosh, almost 30 years, he'll tell you on this neglect idea, and back to the proactive management-based regulation and our work with NLAP, neglect is a key red flag. Not returning calls, not showing up or rescheduling meetings, being late to court, missing deadlines. Those are all things that have a sign of something bigger. Maybe stress at home, maybe financial issues, maybe addiction or dependency, maybe diminished capacity. So that's an area where we're focused on intercepting the issue. Why can't we reach you? Why haven't you updated your office address with attorney services so our letters to you are being returned? The next area you'll see in orange is interference with justice. You say, Mark, what the heck is that? Well, that's basically back to the criminal cases. My judge was evil, the prosecutor was mean, and my client is an idiot. That probably would be thrown in the bag of interference with justice, or more importantly, the prosecution didn't turn over all the evidence, for example. But then you get all the way down the list of all the things. Conflicts run right in about the middle. The failure to deliver client file is a big deal. And some of us still have the misconception that that file is somehow ours, and it's not. It's rarely, if ever, ours. Now, in the criminal arena, I make an exception. I think the traditional response from our office was the client's always entitled to the client file. That was an easy answer. It crossed over any type of case lines. But having done criminal defense, and those of you out there that are prosecutors or defense counsel know that there are circumstances where that file is not to be sent to our client at Douglas County Corrections or wherever. Federal court, they seal the files, and you're not allowed to distribute the materials under penalty of sanction from the court. So sometimes we're just saving our clients from themselves, and we don't want those records all over Douglas County Jail. And they come back to haunt us with people volunteering to be a witness. Or worse, the client or his family on the outside are potentially tampering with witnesses or worse, doing something that may impair the safety or jeopardize the safety of a witness in a case. I'm seeing that I'm getting close to running out of time. The point I think I'll end with is when we switched back my first full year, 2015, to giving attorneys the benefit of the doubt on filing formal grievances, formal charges, or doing a formal grievance investigation versus a preliminary inquiry, that the discipline in the end comes out in the wash. What I'm saying, what I mean by that is, instead of launching cases as formal grievances, which if after investigation we determine there's no merit to the investigation and we dismiss, the complaining party then has the right to appeal my decision within 30 days. If there's a preliminary inquiry under the rules, specifically 9C, I can dismiss based upon a lack of merit, and there is no appeal of that decision. So basically what I'm trying to say is my office is trying to give you the benefit of the doubt by launching half as many formal grievances, opening them rather as preliminary inquiries, and as I state, and I've stated many times before, give me any good and decent reason why I shouldn't dismiss, why I should dismiss a preliminary inquiry, and I will, and there's no appeal of that. But in a formal grievance, if I were to launch an investigation as a formal grievance, then the complaining party will, because if they're upset enough to file a grievance with my office, they're going to appeal my dismissal. And then it goes off to the disciplinary review board, and that's made up of lawyers, your colleagues, as well as lay people. And generally speaking, they are going to pursue charges in at least 50% of the cases. So I want you to know that I'm on your side. I'm there to help. And please reach out if there's any way we can help you with any issue you may have. And with that, I'm going to end this presentation. Thank you.
Hello, everybody. This is Scott Paul. I'm here to give you the online presentation for our Omaha Bar Creighton University School of Law seminar. As usual, my topic surrounds the recent developments of in ethics in the state of Iowa and the state of Nebraska. Today, we'll be focusing on a few of the rule changes in our code of, in our rules of professional conduct. And we'll be looking at 2 or 3 cases where we've got attorney discipline involved that I think will be instructive and helpful to everybody, particularly those who practice occasionally in the state of Iowa, if you're licensed in Iowa. So you'll have to bear with me a little bit as I navigate my way through this process, but hopefully it'll be smooth. We'll start off with a modification to the Nebraska rules. It allows for CLE focusing on technology. This is really a great deal. The section that was amended was in the MCLE section, and it defines professional responsibility to include these technology categories. So as you can see, it includes, professional responsibility includes now information security. For example, that's going to be cyber protection from cyber attacks, that sort of thing, client confidentiality, data breaches, anything related to that. And this is also going to cover the more mundane aspects of technology and the practice of law. And just so long as you can see there, the last bold language I've got there, as long as it's directly related to the ethical issues related to technology, it's going to get MCLE credit or be approved for MCLE credit. This is not a small development because those of us who have tried to put on CLEs in the past have run into problems getting it approved for CLE credit, particularly if it deviated from the traditional areas of professional responsibility. So we were running into problems getting programs approved that dealt with technology when they clearly were related to ethics, clearly related to the practice of law and professional responsibility. But as you may have heard, or as you may have experienced, when you're dealing with the MCLE Commission, sometimes it can be difficult. And so this is one of the developments that was urged by the Nebraska State Bar Association. They presented it to the court after our Professional Enhancement Committee had looked at the issue, and the court had adopted these changes. So this should make it much easier to get technology credit. It should make, and as a result, it should then increase the number of cases, or not cases, but seminars that we have on technology-related matters. So that's a good thing. It was effective June 17 of 2020, so therefore any seminars that you're trying to get approved after that date will have this in enlarged technology capacity. The other thing I'd point out is keep in mind this wellness issue. Professional responsibility has previously been defined to extend to wellness issues. And so if you're looking to take or sponsor or put on seminars that deal with wellness, attorney wellness, those are going to be covered for MCLE credit in Nebraska now. So again, wellness is a very broad issue, but what we see here is a trend where we're moving away from the traditional ethics and hornbook law type seminars, getting into things like technology and wellness. I think is a good thing for all lawyers. One of the things I'll point out is Nebraska got sued for banning law firm trade names. And it was the Counsel for Discipline. I think Mark Weber got sued on this earlier this year. I think it's been resolved. What happened was an outfit called Law HQ, which is a trade name for a law firm. They sued disciplinary and bar officials in 9 states that it had language in their model rules of professional conduct that barred the use of trade names unless it had certain circumstances. For example, Nebraska's old rule on firm names and letterheads was in Rule 7.5, 3-507.5. And it said a trade name may be used by a lawyer in private practice if the trade name includes the name of at least one of the lawyers practicing under said name. Well, the model rule didn't have that requirement. And so, and many of the other states obviously did not either. And so eventually this became a big enough issue that lawsuits were filed. And the lawsuit contended that this trade name ban or the requirement to include a practicing lawyer's name with the trade name served no valid purpose. And they really raised a good point. They pointed out that many of the existing firm names are potentially misleading, at least, because they often have the names of partners who are retired or deceased. And I can relate to that. I mean, McGrath, North, Mullin, and Kratz, all are deceased. Other law firms, Coley Jessen, Kutak Rock, Fraser Stryker, I think we see Barrett Home, we see many of the bigger firms in the state of Nebraska, Klein Williams, they fit the bill here where they're permitted to have those names and have the firm name and letterhead using those names, even though the partners are retired or deceased. And so Law HQ looked at those and say, how is that not misleading? And yet our trade name that we want to practice under is misleading. So the rule was eventually superseded. It basically repealed such that 3-507.5, and here's the former rule here in Nebraska, if it included the name of at least one of the lawyers practicing under that trade name was the requirement. That was repealed by our Supreme Court. And the remaining provisions of Rule 3-507.5 that survived the repeal aren't there anymore, but they've been moved to the comment in 3-507.1 dealing with advertising, and it's comments 5 through 8. So the guts of that rule has still survived, but it's now found in a comment to Rule 7.1. So now in Nebraska, you can have trade names. They don't have to have the name of a current partner or current lawyer affiliated with the trade name in the name. And of course, the exception or the rule that allows law firm names to include or consist of deceased partners or retired partners has been retained. So it doesn't change the law with respect to any of the the law firm names that exist with respect to persons' names in them. It just broadens the law now to say you can have trade names, and those trade names don't have to have a lawyer's name in the name itself. So that was a good development. I think it ultimately brings Nebraska and I think these other states into line with the rest of the country. Like I said, I think they raised a good point that it arguably is a bit misleading to have the names of retired or deceased partners in the firm name or on the letterhead, but yet you can't do it with a trade name. So anyhow, that was, I think, a good development. And so this slide just kind of summarizes what I just said about the firm may still be designated by the names of all or some of the current members, and you can have trade names as long as it's not false or misleading. And I should just stop here and just point out that any of the advertising rules are always going to have that caveat. There's a huge exception for any advertising rule, whether it be letterhead, whether it be firm names, whether it be advertising into the general public, as long as it's going to be largely permissible as long as it's not false or misleading. But anything that is false or misleading is going to be prohibited by the rules, and that hasn't changed and shouldn't change. Now, here's a category that I thought was interesting. It came up in an Ohio case that I thought it would be a good topic for discussion here today. Do you represent your client zealously? Well, what do we mean by that? Well, the preamble, and many of you have heard me talk about the preamble in the past. It's the very first section of our rules of professional conduct, and it has various statements or goals or aspirations, and one of them is in section 2, where we are required to zealously assert the client's position under the rules of the adversary system. Also, section 9, the preamble, the lawyer must zealously protect and pursue a client's legitimate interests, of course, within the bounds of the law. We don't see that language used very often in our normal course of business. In our normal day, we don't talk about zealously doing this or zealously doing that. And I think we need to start from where does that language come from? And the origin is in the duties of competence and the duties of diligence. And basically what they're saying there is that you gotta be hardworking, you gotta be devoted, you gotta be loyal to your client, that sort of thing, in order to satisfy this rule of being zealously representing your client. But the Supreme Court of Ohio deleted all references in their rules to zealous advocacy. The basis for which they did so was they said, look, this is an excuse for unprofessional behavior. People can say that they were doing this or doing that or being obstructive in a deposition or scheduling or some of the common courtesies that we see, because the code of ethics requires them to be zealous in their representation of the client. And so they would point to that as being something that the ethics rules required, and so they weren't being unethical or they weren't being unprofessional for doing so. And the Supreme Court of Ohio said, well, we're going to fix that. We'll just take zealous advocacy out and we'll eliminate that excuse. So the question I pose to the group here today is, should the requirement that a lawyer act as a zealot be retained in the Nebraska rules of professional conduct? And you'll note that I changed the word from zealous to zealot, and I think being a zealot is even worse. It sounds even worse. It has some pejorative connotations to it. And when you look it up, it talks about someone that the definition Merriam-Webster online talks about someone who acts in a fanatical way, and it's generally a negative definition. And so the word zealot, which is derived from zealous, is not anything that casts lawyers in a good light. And so we hear so much about professionalism and working with other lawyers to get to the heart of the matter and not get caught up in procedural problems and dead ends and making things more difficult than they need to be. Well, that's part of professionalism. And if we're representing our client as a zealot, that suggests that perhaps we're not being professional. So it doesn't mean we shouldn't be competent, doesn't mean we shouldn't be devoted, doesn't mean we shouldn't be diligent in the representation of our clients. But the word zealous, if it was removed from our Nebraska rules of professional conduct from the preamble, I think it would probably be a good thing because it reinforces the concept of professionalism. Let's move on to the Barfield case. And this is, I'm going to run through this very quickly because I don't think I can reinforce this or state this enough. And apparently, as you'll see from the quotes here, the Supreme Court doesn't think they can reinforce it or restate it enough either. This is a case where the attorney violated a rule against commingling of funds with the client with those of the attorney, such that their separate identity is lost. And so it's basically you're putting these funds in an operating account or you're taking these funds out of a trust account and putting them somewhere else for whatever purpose. And whatever that purpose is, it violates the Nebraska rules of professional conduct. So the court points out in Barfield, just some reminders that they want to emphasize about this conduct. It can be in good faith or you could be ignorant of the rules, but neither of those provides a defense to a disciplinary charge that you've commingled client funds. And it's important to note that even when the client suffers no loss, when there's been this commingling, the court says, look, this is not a trivial or a technical rule, it's not an accounting problem, it's not a bookkeeping problem, even though the client has suffered no loss. So if you've got commingling, the court is trying to signal that this is a serious offense. And the court notes, because it's dangerous, and unfortunately, the court notes a common basis for disciplinary action. That's where the court's telling us this happens a lot. And they're trying to sound the alarm that it's happened in other cases that I talked about in the last couple of years. It's still happening, and the court is really trying to send, as they say, a strong message to deter this conduct. So in this case, the attorney was disbarred, and the court held that disbarment was warranted due to the commingling that occurred, and she offered some mitigating factors about she cooperated with the Counsel for Discipline. She was remorseful. She had prior good civic activities that she'd been involved in. The court said none of that stuff counts when we've got a commingling of funds. Disbarment is the sanction. And so, again, I put it in the seminar this year just so that everyone is recalling that you don't need to have a client loss of funds here. You don't need to have theft. It could be a simple bookkeeping mistake. It could be an accounting mistake. But if that happens, you need to be very careful how you approach this because you're right on the edge of severe discipline from this Supreme Court and Counsel for Discipline. Now, I want to take an opportunity to talk about this next case. It's a 2020 case over in Iowa where a Nebraska lawyer who was a member of the Iowa Bar was practicing in Iowa on an estate. I'm not bringing this up to cast any aspersions or place this lawyer in a negative light. All I'm trying to do is make you aware of some of the problems that you can run into in the state of Iowa if you're practicing over there and you don't practice in Iowa on a regular basis. Even though I'm a member of the Iowa Bar, at this point it's been long enough since I've handled an Iowa case that if I had a case over in Iowa, I would associate with local counsel just to protect against any problems. So what happened in this case? Well, I'm going to show you excerpts from the Iowa Supreme Court opinions so that you get a feel for the offense here and the discipline handed out by the court. So the attorney was admitted to practice in Nebraska in 1979, over in Iowa in 2000 when the rules were loosened up to allow non-resident lawyers to practice in Iowa. The law office was in Omaha. He was appointed administrator of his uncle's estate in Iowa, and TS Bank, it used to be Trainer State Bank, I believe, was appointed the executor. The estate was represented by a different lawyer. What I mean by that was that there was a lawyer involved that would typically handle the estate, but this attorney that we're talking about that was disciplined was appointed the administrator. And so I think the situation, and you can't tell from the opinion of the court, but I think the situation was that this uncle died without a will. So he was appointed as the administrator of the estate as opposed to the executor or personal representative if he had died with a will. I think the uncle may have been under a conservatorship at some point toward the end of his life, and if so, then the TS Bank was appointed the executor to carry on that conservatorship. I think they were the conservator And so they were now called the executor. I point those out just because the opinion doesn't really define what those terms mean or how they apply here, but I think just so that it's clear to you, I think that's the explanation for those terms. After the estate was opened, the attorney as the administrator, or the person handling the estate, not the attorney that's representing the estate, because usually it's not uncommon to have persons that are administrators who aren't attorneys, obviously. Could be wives, husbands, son, daughter, that sort of thing. Here, it just happened to be the attorney, the administrator was an attorney. And he wrote checks on the estate's bank account to himself that totaled about $39,000. Now, there's actually the amount that he came to his benefit was $29,350. There was a tax issue. There was a payment made on a tax issue that I think the court has excluded from this discussion. So we're really talking about $29,000 that this attorney paid to himself out of the estate. In terms of the beneficiaries, the uncle's wife, this attorney's uncle's wife, his aunt, was still alive for part of the administration of this estate. The problem was the attorney did not obtain Iowa court authorization prior to making any of these payments to himself, and presumably did not address these payments or talk to the lawyer who was handling the estate about making these payments without court order. The lawyer representing the estate reviewed the documents that the attorney had sent him and noticed that there were these unauthorized payments. He quickly contacted the lawyer, the attorney, and I'm distinguishing between lawyer and attorney just so you can keep track. The attorney is the one who's getting disciplined here. The lawyer was the one who was representing the estate. And to the attorney's credit, he made no excuses. He took full responsibility for his conduct and said, yes, I did take those payments out of the estate. They were payable to me to reimburse me for fees and expenses. And I admit that I didn't get court authorization. So he was very forthright in terms of dealing with the offense once it was brought to his attention. He actually repaid the funds to the estate with interest within 2 weeks of this meeting with the lawyer for the estate. Then the widow of the original estate, decedent, the aunt, she passes away as well, and so her estate is opened by yet another lawyer. The reason why that's important is two reasons. Most of these checks were written by the attorney prior to the aunt's death. So she was going to be the sole beneficiary. So it appears from the opinion that those checks would otherwise have been payable to her, or that those funds would have been given to her through the probate process. Instead, they were checks written by the attorney prior to the aunt's death to pay for his fees and expenses. And so we'll talk in a little bit about his fees and expenses and how much they were, but clearly this was not a situation where he was about to inherit the entire estate, and it's not a question of whether he was receiving these funds just without court order when ultimately they all would have come to him anyhow. The fact that the aunt was still alive while he was handling the estate and she was the sole beneficiary meant that those funds were going to her net of his approved court costs and attorney fees. The other lawyer that was hired, yet another lawyer to handle the aunt's estate, was frustrated. He wasn't getting information he needed from the attorney regarding the uncle's estate in order to process the aunt's estate. So he filed a motion to remove the attorney because nothing was happening in the uncle's estate. The order removing the attorney as administrator of the estate found that the attorney had mismanaged the estate, largely because of these payments that had been made to the attorney without the court approval. And also, I suspect that the time that had lapsed in handling the estate was also a factor here. It should be pointed out again, in fairness to the attorney who was being disciplined here, he did in fact self-report to the Iowa Counsel for Discipline the unauthorized payments that he obtained from the estate. So what was he charged with? Well, he was charged with two things: violating Rule 8.4, which in Iowa is 32.8.4B, and 8.4C. And if you recall some of my previous ethics presentations, whenever we're talking about 8.4, I referred to that as the sledgehammer. That is the most serious ethics charge that you can bring against an attorney, is a violation of Rule 8.4. And basically 8.4b, committing a criminal act, or 8.4c, involving dishonesty, fraud, or deceit. You don't need to be convicted of a crime to be found in violation of Rule 8.4b for committing a criminal act. But basically, these are the things that the court and the Counsel for Discipline use to police attorney conduct, so that they are honest, trustworthy, and not misrepresenting things to clients. They're very, very serious allegations. So I think in order for you to get some idea of what went on here, there's two excerpts in the opinion that I have included verbatim here, and I think they bear reading, because it gives you some indication of what the attorney's mindset was, and he was a very effective witness for his own behalf, as you'll see here. Question, this is coming from the referee. Your position at this hearing, though, is that you didn't violate either of the rules that the board is alleging you violated. Is that correct? Well, I think they have to prove that I had a mental intent to steal, and that was never the case. It's called scienter. Unless they prove scienter, their case fails. I think the testimony was from both the estate's lawyer and TS Bank, meaning the lawyer he had hired to represent the estate, and TS Bank, which was the executor of the conservatorship, was that they never believed that I was stealing, and I never had an intent to steal. In fact, I always had the intention of disclosing. That's one of the reasons why I used checks. I didn't use an ATM. So the attorney's saying, look, this was all out in the open. Nobody thought that anybody was pulling a fast one here. And so that's why you can't prove the charge of intent to deceive, because there's no scienter, the old 10b-5 securities regulation term, scienter. He goes on, was it dumb for me to do it without court order? Amen, brother, that's me. I'm the poster child for that. I admit that freely. Did I deceive anyone? Without deception, the second allegation, there has to be deception or a cover-up. No evidence of a cover-up or a deception. And so you can see the attorney is making a good argument on behalf of himself by saying that the Counsel for Discipline in Iowa is not proving their case based on the charge that they made against him. The missing element here is deception, and he didn't deceive anybody. At least that's what the attorney was claiming. So the referee then went further and said, so your position is that you did violate ethical rules, they just haven't alleged the right ethical rules that you violated. Is that right? And then he says this, answer, I'm saying we're responding to what they alleged. I'm not going out looking for ethical rules to be violated. I'm not going to do their work for them. Come on, I've already fessed up. What more do you want me to do? Well, first of all, he's treating this case as if it's a criminal prosecution, and to his credit, he makes some convincing points, at least he did with the referee, about he's responding to what they alleged. But the tone of that response about he's already fessed up and what more do you want me to do probably wasn't the best choice of words. It may have been frustration of this lawyer, but I'm sure that it wasn't probably the best choice of words as it sounded or was perceived by the referee in this case. So the referee, which is the commission, they actually dismissed the 8.4b charge of deceit and fraud, which is what the attorney had been arguing. But they did find that the attorney's unauthorized fee payments violated 8.4c. Again, they found deception existed here. And the board contended, the prosecutor, the Counsel for Discipline is the board, it contended that suspension of the attorney's license was an appropriate sanction. The commission, on the other hand, the referee, recommended the attorney receive a public reprimand. So the attorney was in a position after this trial of facing only a public reprimand, which would have been a tremendous development for him. Well, the court noted that the disciplinary board, meaning here at Counsel for Discipline, must prove ethical violations by a convincing preponderance of the evidence. That's somewhere between preponderance of the evidence and reasonable doubt standard. And it's, who knows what that means. The fact that there's a standard called a convincing preponderance of the evidence Does that mean there's something called, that can be called an unconvincing preponderance of the evidence? It's a difficult concept to grasp, but basically they're saying you need to have more evidence than just a preponderance. The court also said we can impose a greater or lesser sanction in attorney discipline cases. And that's, as I say here, that's a bad omen. Whenever you see the court talking about its authority to impose a greater or lesser sanction, they rarely impose a lesser sanction. It's usually the prelude to bad news for a more severe sanction. And so the court noted to prove a violation of the rule of professional conduct from engaging in deceit, fraud, misrepresentation, the court has to show scienter, so that's correct. And that's also found in Rule 8.4c, and that's satisfied when there's this knowing or intentional conduct. On de novo review, the court concluded that there was a convincing preponderance of the evidence that the attorney violated both rules by misappropriating the funds, so both A and B of 8.4. And the court pointed out that because he was the administrator of the estate, he owed a fiduciary duty to the estate. So it was another basis upon which the court could conclude there is some objectionable conduct here by the attorney. So to prove a violation of the rule, the attorney had to act with scienter, and we noted, I think I just showed you that slide. Moving forward here at the commission hearing, when asked why he made payments to himself without a court order, the attorney replied, the honest answer is, I didn't know I needed a court order. All right, so here's where we get into some of the more interesting parts of the case, and this is really why I wanted you to see this, is because the attorney's done a fairly effective job of defending himself through this trial before the referee, but in order to justify its action, the Iowa Supreme Court dug into this case and dug into the record fairly deeply in order to justify its charge or its conclusion that he violated both 8.4a and 8.4b. And so as it relates to ignorance, where he says, I didn't know I needed a court order, this was because he said he didn't think that Nebraska law required an administrator to obtain court order prior to payment. And because he practiced primarily in Nebraska, he was following Nebraska law and administering the estate. So again, there was no scienter, he was just following the wrong law. Something to keep in mind here is that the Nebraska law, he may be very well correct in terms of what Nebraska law requires in that regard, but if you're practicing in Iowa, Nebraska law is not going to carry you very far. So the evidence as developed by the Supreme Court and the Counsel for Discipline noted in the opinion, this attorney had worked on other states in Iowa where he had obtained court approval for prior to payment of the fees. In one case, the attorney served as the attorney for the personal representative of the estate, and he filed an application where he noted that there was a maximum allowable fee in Iowa. And basically, there is a ceiling or a limit on the fees that can be paid in probate cases in Iowa, and above that fee, there has to be special approval by the court to get something higher than the maximum allowable fee under 633.197. And those cases are generally more complex cases that require a lot more work. The court also pointed out that there was another Iowa probate case where the attorney filed a document where he alleged that fees for ordinary services were fixed by the court. So they found these other cases where he was fairly well certain of what the rule was in Iowa, and then when they pressed the attorney on the issue at the commission hearing, the attorney testified, well, he really didn't know what he was doing, and he just filled out the forms because the judge told him what to do in the Iowa probate cases that he handled. And so the conclusion of the court was, the Supreme Court, in light of his 40 years of experience as an attorney, his denial of a rudimentary understanding of Iowa probate law, quote, falls flat, end of quote. And so that was the language used by the Iowa Supreme Court. And obviously, they were not impressed with his argument. They found that the unauthorized payments had no relationship to the fees allegedly earned and expenses allegedly incurred in the case. So when he tried to line up the fees that the payments that he'd been receiving to the work that he had done, the court noted and discussed the fact that they just didn't line up. There was no relationship there. So then the discussion turned to a colorable claim, and this was basically to address now the penalty. The general rule is where there's a misappropriation of funds held in trust, which we had here, it results in a revocation of the license of the attorney, except in instances where the attorney had a colorable claim to, or a colorable future claim to the funds. So for example, if the attorney was the ultimate beneficiary here, the fact that he took some funds out without court approval or did so before he was entitled technically to the funds would be a colorable claim to colorable future claim to these funds. That isn't the case here. As I noted, the wife was the sole beneficiary, the aunt was the sole beneficiary here. And so the court noted that the attorney's claim that he had a colorable future claim is implausible because he took $29,350. The ordinary fee for that type of an estate, these simple estates, would have been capped at $9,263 plus court costs or necessary expenses. And so it was about 3 times the amount he received. And that's why the court said, look, there's no relationship here. And we find that it's an implausible claim that there was some colorable future claim to these funds by the attorney when we have this kind of discrepancy. And so the court said when the attorney converts funds without a colorable claim, we don't need to consider mitigating or aggravating circumstances. It speaks for itself. And so there weren't any mitigating circumstances considered. And so the court ended up revoking the attorney's license where he was practicing as a fiduciary, as in this case. The court noted that the evidence showed that he had filed applications for fees and other probate matters. He acknowledged the statutory cap. The fees had no relationship to the amount charged, the work actually done. The estate had only a single beneficiary. There weren't any legal issues, no litigation, no taxes, tax issues, no complex issues presented. The contention he had a colorable claim to the $29,000, according to the court, in a very, very simple estate is implausible, especially given the statutory cap. And so the court ordered revocation of the attorney's license, with the exception he could reapply to the Iowa Supreme Court for admission in 5 years. He would have to demonstrate trustworthiness and good moral character to do that and have his application favorably received. But they ordered revocation of his license in the state of Iowa. So I point that out for the main reason that if you're a Nebraska lawyer going over into Iowa, particularly if you're handling probate or estate cases in Iowa, obviously you can't rely on the defense that I thought it was legal under Nebraska or I didn't mean any harm because you could do that under Nebraska law. That's not going to be receptive to the court if that happens. So make sure if you're going to Iowa and you're handling cases over there, whether they're probate or not, whether you're a member of the bar or not, make sure you understand the rules, because this is a case that I think a lot of courts will point to in Western Iowa in particular, when they see Omaha lawyers coming over to Iowa to take cases in the state of Iowa, even though they're members of the Iowa bar, they will remember this case. And for that reason, you should too. So the next case is the Counsel for Discipline versus Hansen. This is really a simple violation here. I'll run through it quickly. Hansen was alleged to have violated a number of rules by preparing documents for his girlfriend without including a, quote, prepared by notation. And we like to encourage lawyers to help pro se litigants on scope of representation issues by, doing certain things to help them move their case forward, even if they're not going to have a lawyer. And by including a prepared by notation is one of the ways that the attorneys can help clients without actually entering appearances in cases. In this case, Hansen was admitted in 2011, and importantly here, as you'll hear later, he served as the county attorney for Valley County for 4 years. And what happened was CS was a self-represented litigant. This was his girlfriend, Hansen's girlfriend, and there had been documents filed by CS that contained indexing notations consistent with other documents that had been prepared by Hansen. And I think what that means is they could figure out who wrote the documents, even though they didn't say prepared by Hansen on them. There must have been metadata or certain little footers at the bottom that they were able to trace these documents. And the court held or stated that as a self-represented litigant, you've got to, if you're drafting pleadings, you have to include this prepared by notation. And it did, the amended complaint in the case did have such a notation. It's just that the previously filed pleadings did not. So the Counsel for Discipline gets out the baseball bat and charges Mr. Hansen with all kinds of different violations. 1.2, scope of representation. 1.7, conflict of interest. 3.3, lack of candor to the court. 4.3, dealing with unrepresented persons. And 8.4, again, 8.4 is that sledgehammer misconduct rule. And all because the attorney did not include a prepared by notation on the bottom of the pleadings that he prepared for his girlfriend in this lawsuit. Now, there was one other aspect of it, because he was county attorney, and as I'll mention here in a minute, there was some litigation going on. The court found that there was a conflict of interest. But I'll get to that in a minute. Obviously, the Counsel for Discipline also alleged that he violated his oath of office. The referee recommended a 6-month suspension. So that's a pretty stiff suspension, but there were a lot of charges brought against this attorney for this failing to have the prepared by notation. So he explained his conduct. He said, look, I'm merely trying to ensure they were well-drafted documents, and it was an inadvertent mistake. And after he learned about the mistake, he corrected it and placed the required information on the amended complaint, which he did. The court stated, we're not suggesting that that Rule 1.2C requires a prepared by stamp every time a self-represented litigant receives assistance from a lawyer. It's only when the lawyer actually prepares the document. Now, here's the backdrop that gets him into a conflict of interest problem. The Valley County Sheriff was deposed during this litigation because he was the county attorney at that time and was involved in the case to the extent that he was. Outside counsel was appointed, and based on the evidence presented along with the admissions of Hansen, the court found that there was a clear and convincing conflict of interest here, that he should not have been acting on behalf of his girlfriend when the county sheriff, basically his client, was being deposed in the case. The ABA has weighed in on this issue, not on this case, but on this issue, and they noted that the attorney's failure to disclose behind the scenes assistance is not all that bad. It doesn't secure unwanted or unwarranted special treatment for litigants, and the ABA was generally in favor of this type of conduct. The court noted a failure to include the prepared by notation does not constitute a violation of 4.3, and so that was good for Hansen. Then he admitted that failing to include the prepared by notation constituted misconduct, but again, he denied violating the rule because he did not intend to mislead or be dishonest, just as we saw in the other case. The court held that proof of actual intent to deceive or defraud was not required, but the court also said there's insufficient evidence to demonstrate that Hansen violated 8.4C, and that conclusion was supported again by an ABA opinion that said that when you have this failure to disclose the preparation of document, it doesn't constitute 8.4 dishonesty, fraud, or deceit. And so if this defense by the attorney was worth nothing else, it was worthwhile to get this charge removed from his record, because this is the most serious charge that can be leveled against an attorney. So the court ruled in his favor there. So the court stated, for cases involving conflict of interest, the court has generally imposed just a public reprimand. In this case, the violation of Rule 1.2C, the court recognized the violation was unintentional. There aren't any comparable cases in Nebraska, and so the court went along with a public reprimand for Hansen in this case, which really was a victory for him because he admitted that there was a violation. The Counsel for Discipline was seeking a suspension and recommending a suspension in this case. So it was a worthwhile defense on his part to get rid of the 8.4 allegation, and also to knock this penalty down to a public reprimand. But anyhow, it gives you just an indication of how much trouble you can get in when it's a very simple violation, but these violations of one rule can be violations of other rules, and it can kind of snowball, and which is what happened in this case. But at the end of the day, the attorney did not have any fraudulent or deceitful intent. I think that went a long way toward helping him in this case. So just a public reprimand, just another reason why we want to make sure we're very careful when we do these prepared by notations. If you're doing that, it's a scope of representation issue, and make sure you're disclosing where necessary. So now we've come to the fastest 5 minutes in ethics, and I'll see where I am on my time. Getting close to the end. So it may be less than 5 minutes. Nebraska Opinion 1902, it came out last year. Can a law firm use a trade name or service mark that does not communicate the law firm's professional entity designation? All they're talking about here is, do you have to say, if you've got a trade name, do you have to put LLC behind it, PC behind it, LLP behind it, one of those types of references? And the court said, yes, you can use your trade name, and you don't need to have those references, those professional entity designations, as long as the communication, both in the law firm name or on the letterhead or in advertising, is not false or misleading. If you are in-house counsel in Iowa, just a heads up, the proposed rule that is, the Iowa Supreme Court has amended the rule, and it removes the 5-year limitation on house counsel debt registration. So you can be an in-house counsel under the registration of in-house counsel rule in Iowa for more than 5 years. You're not just limited to 5 years anymore. It may not apply to very many people, but it's something that helps lawyers, makes it easier for lawyers to practice as in-house counsel in Iowa. On the Chavala case, I just point this out that if you've got a case that involves negotiating the purchase of land, where you as the attorney have an ownership interest and you represent a party regarding these land ownership issues and lease issues, you need to be very careful. And the court ended up disbarring the lawyer in this case because of the violation of conflict of interest rules. And again, dishonesty, deceit, misrepresentation, that's rule 8.4, that's the sledgehammer. Because it's the fastest 5 minutes in ethics section of this part of the seminar, I'm not going to go into detail on this 50-page Westlaw opinion, but it is available for your review if you're interested. Iowa CLE by reciprocity, something to keep in mind, especially as you get to December and you're trying to figure out your CLE hours if you're an Iowa lawyer. There's a reciprocity rule that's been adopted in Iowa for out-of-state lawyers. So for example, me, a member of the Iowa Bar, living in Nebraska, what I can do is I can attend and satisfy all of my Iowa CLE by attending Nebraska CLE, as long as it counts for accreditation in Nebraska. Now, Nebraska is only 10 hours, Iowa's 15, so I'd have to do 15 hours of Nebraska CLE, but if I can do 15 hours, that's going to satisfy the requirement in Iowa, as opposed to having to get Iowa CLE to satisfy those 15 hours. Now, that only applies if you are no longer practicing in the state of Iowa over the last couple of years. You'll need to take a look at the rule on this, but if you're regularly practicing in the state of Iowa, this rule does not apply to you. You don't get the benefit of it. But if you haven't practiced in Iowa in several years, and you're trying to keep your CLE up for Iowa and trying to keep your bar admission over there, I think you just need to be able to certify you haven't practiced in Iowa for the last year, and then you can use your Nebraska CLE credit for Nebraska and Iowa just as if you would have had Iowa CLE credit. So if you're interested in this issue, this reciprocity issue, it is Rule 41.9 of the Iowa Supreme Court Rules of Practice. Take a look at that. It may be able to save everybody some time and money in terms of MCLE matters. So what have we learned? We learned that advertising the firm name in the firm name and in the letterhead, it shouldn't be false. It shouldn't be misleading. Again, that's the guiding principle through any of these issues with letterheads, firm names, and advertising. We've learned that law firm technology is now a proper subject for mandatory continuing legal education in Nebraska. And as I pointed out earlier, if you're a Nebraska lawyer and you're practicing in Iowa, in light of this opinion with the estate, particularly probate cases, you're going to get all the scrutiny that you can handle to make sure that you're practicing in accordance with the Iowa probate laws and not the Nebraska probate laws. So be very careful of that if that is a case that you're handling. So that brings us to the end. I think I'm right about 45 minutes. It was a pleasure to be able to speak to you. I wish it was in person, but at least we were able to run over some of the most recent developments in Iowa and Nebraska. Hopefully this was helpful to you, and best of luck.